Call the final case on the morning docket, 106150, State versus Sharkey.
Michelle Davis on behalf of the appellant, Mr. Sharkey, and could I please reserve 3 minutes for rebuttal?
3 minutes, thank you.
Justice Lukert, thank you. It appears, there's 3 issues in the brief. It appears issues 2 and 3 have been addressed in one way or another. So I'll focus on issue 1, which was Mr. Sharkey, shortly after the verdict, filed a motion seeking a new trial, a pro se motion seeking a new trial, asserting that his counsel had been ineffective at trial and requesting the appointment of new counsel. And our issue is that he did not receive conflict-free representation on that motion for new trial, and that the district court erred in proceeding to summarily deny that motion without appointing him conflict-free counsel. And it's interesting, I think one thing I want to clearly establish is that this was still a challenge to the conviction. This is not, I don't think we're subject to the case law here, as you would with a 1507.
I'm sorry, I missed just the last couple of phrases.
I don't think we're subject here to the case law that applies with a 1507 post-conviction case law, because he's still challenging the conviction here. The conviction's still in play. And so on that basis, in our brief, he's entitled to the representation of counsel. He's entitled to the representation of conflict-free counsel. And instead, the district court never really addressed that issue.
Help me with that.
Uh-huh.
The distinction is that he still has the constitutional right to effective counsel rather than the statutory right to effective counsel, which we've said applies in the 1507. Is that what you're saying?
Well, the state, in our brief, I basically cite the cases that talk about, when there's a hearing, you have the right to have, it's a Supreme Court case that talks about Taylor. If a hearing is held and the state's represented, the defendant should be represented by conflict-free counsel, unless the defendant waives the right to counsel. And then obviously the Sixth Amendment's implicated with the idea of the conflict-free counsel, and then you've got the state statute that says you're entitled to the assistance of counsel at every stage of the proceeding, and that this is still part of the trial proceedings because he's challenging his...
Bottom line, you're saying the post-trial motions are still a critical stage of the proceedings for Sixth Amendment purposes?
Because, yes, because he's still, yes. And so the cases of the state cite in its brief more go to a 1507 type proceeding, because the state's trying to sort of say, well, the judge didn't have to appoint him an attorney here. And the judge pretty much said to Mr. Sharkey, well, let me hear your motions first, and then I'll take up your counsel's, because his counsel had filed the typical motion for new trial also. And Mr. Sharkey said he didn't have anything to say. Apparently, Mr. Sharkey was confused because the court said, let's see if I can get this right, do you wish to address the court? And he said no. And he said, are you going to stand on your written motions? And Mr. Sharkey said no. So that's a little bit contradictory. And then the court summarily denied the motions without really addressing the merits of the motion. And so it's our contention that we can't really even address the merits of the motions because they weren't fleshed out, because there was no hearing. And what he's asserting in these motions is a type of thing that needs to get fleshed out, because he's basically saying it was my trial, my counsel sort of said it was a strategy not to testify. And I was hoodwinked, and then he makes some, so that basically comes down to conversations between client and attorney. And this was a household situation. This was an Ag and Decent Liberties, but it was a friend of a child in the household, and Mr. Sharkey's alleging that there was conflict, and apparently there was testimony at trial that there wasn't conflict. He's saying he had conflict with his wife's daughter, and that was sort of his defense. And he's saying that his attorney never investigated that and didn't talk to family members, and that those family members could have provided that evidence to support his defense. So basically, he's alleging things in his motion.
I have a fact question related to that, though. Wasn't the conflict with the daughter a different daughter than the one who was a friend of this girl?
You know, and Justice Breyer, I'm not real clear on that because, again, I don't think we can challenge the merits here because I didn't challenge the merits in my brief because none of this got fleshed out.
Okay.
But I'm just trying to paraphrase what he alleged in his motions.
So there's nothing in the record that would answer that question. There's nothing in the record that tells us that there'd been any conflict really that would have involved that girl, the victim, somehow, right? There's just nothing
Right.
there. And you're saying that's evidence of your problem. He should have had a hearing.
Right, I don't really have any details to go with because there was no hearing. And in the district court's position, one thing I also want to make clear is that the district court's position here was, he told Mr. Sharkey, if you feel strongly about this, you can raise this issue of ineffective assistance of counsel in your direct appeal, or you can raise it pretty much in a 1507 in a post-conviction proceeding. But, you know, here we are. This happened in 2006. This trial was in 2009. Here we are in 2013. Obviously, there is some benefit to a defendant of having this issue heard right after the trial, when everyone's memories are clear, when you can bring in these family members, when witnesses are available. So I think there's a question that this court needs to address. Is that correct to just be able to say, well, you can do this later, so I, as a trial judge, I don't have to hear this issue now, when there's clearly some benefit to the defendant to say of doing this now, of bringing his attorney in and when memories are clear, instead of trying to bring this up 7 or 8 years later when witnesses may not be available and memories are not as good. So I think there is clearly a disadvantage to a defendant from a trial judge just simply being able to say he's got a right to request a new trial. There's a statute that gives him that right. He's raising a basis to say, I did not receive a fair trial. My attorney was ineffective. I did not get to present my defense. He's got a right to assert that and to ask for a new trial on that basis. And for a judge to just simply say, well, you can raise this later, we believe is inappropriate.
If the judge had addressed it at that time and asked some questions of Mr. Sharkey, do you think, at least as I see the state suggesting, that would have been sufficient?
I'm sorry, Justice Luker, I'm not sure I understand your
Would
question.
you have an issue if the judge had asked some questions of Mr. Sharkey and Mr. Sharkey had responded? If there had been a dialogue about a fleshing out of the questions and answers at that point in time, would you still have an issue of ineffective assistance of counsel? Or do you think it would have been cured by questions and answers?
The problem with that is Mr. Sharkey does not appear to be the type of person who's comfortable holding that dialogue with the court. And so the advantage of having an attorney is somebody who can represent your position instead of you trying to do it yourself and then not speaking adequately and then saying, well, you didn't state enough on the merits.
So the only
proceed further.
remedy would have been to have continued the hearing, appointed conflict-free counsel, and then.
Yes, and I think I was confused by your question because I wasn't sure if you were asking would it have been appropriate for him to talk to Mr. Sharkey about whether there was a conflict or not, and whether he wanted to proceed or appoint new counsel. But I think that's kind of already addressed because the motion clearly shows there's a conflict, and Mr. Sharkey had filed a motion asking for a new attorney.
So those questions have already been answered in your mind, and the judge should have just proceeded to appoint new counsel at that point.
Right. Yes. Thank you.
If we would say this falls within a category of you're needing to show prejudice, how would you answer that? What prejudice would you say resulted by the judge's actions here?
Well, I think the prejudice is what I talked about earlier, that this is shortly after the trial, when memories are fresh, when witnesses are available. And so that would be the prejudice, that by having a hearing, and certainly there's advantages to doing it both ways, but by having the hearing right after the trial, you're going to get a better, I think this defendant would have received a better. Of course, the only remedy that this court can do at this point is to send it back for a hearing on this motion. So for this particular defendant, but that is the prejudice.
It seems to me that your client, this is not an unusual course for your client, let's put it that way. I think there were 4 different times in which he's claimed each one of his trial counsel on 4 different occasions were ineffective. And now you're suggesting to us that he didn't know how to approach the court with that concern in this post-trial proceeding. And what's to prevent this? I mean, this is just going to be something that one might predict based on past behavior that's going to constantly occur every time he's appointed counsel.
He seemed to do fairly well with filing the written motion part. I think that speaking to the court part is where he didn't seem to do so well with. And in terms of constantly occur, I mean, this is one motion for a new trial. He's only going to get one shot at this.
I understand.
And I think that's my other concern in answering Justice Luker's prejudice is, you know, the state saying, well, he can file a 1507. Technically, there's been a ruling on the merits here. I mean, you've got a judge that's denied his motions. It's possible that if he tries to file a 1507, the state can say, this has been heard. This has been ruled on. I don't know how that's going to play out.
I think we've said that when we've had a Van Cleve hearing, they raised some issues and then wanted to raise more in the 1507. We said you get one bite of the apple.
As long as you were same counsel, trial counsel. I'm a little confused by your response and then
Okay.
kind of what I perceived to be a reference back to that response just now. Justice Lukert asked you if it would have been enough if the judge had merely questioned Mr. Sharkey and then by that question and answer procedure satisfied the judge that there was not a problem and then ruled. And I think you said the problem is that he was apparently not capable of handling the oral argument on his own. But is that really the only problem? Aren't you making a legal argument that any defendant in this position who alleges that he or she has received ineffective assistance of counsel by way of a motion for a new trial things have to stop
Yes.
until they have counsel?
Yes, I misspoke. I
Okay.
misspoke.
I was just confused. I just wanted
Yeah,
to
because you're right.
clarify that my
yeah.
earlier understanding of your argument was correct. Okay, thank you.
I kind of misspoke because I mean, ideally there would have been some dialogue here, but really, you're right. I mean, what's the point of having that dialogue when?
Unless he's
Yeah.
affirmatively asserted his right to represent himself,
Right.
then he has a right to counsel at that point.
Right.
That hasn't been waived. And if he says, my counsel and I have a conflict, and the judge hears that and can't satisfy, if it's conflict based, I suppose the judge can satisfy himself or herself that there is no conflict. But if there's a question about whether a conflict exists, then your position is things have to stop.
Right.
New counsel has to be appointed.
Right. And I've seen that in other cases, and that's what's particularly troubling because other district court judges will just do that.
We've had this issue a couple times in recent appellate
Right.
cases.
And you'll see cases where they do that, and they'll just say, I'm going to appoint new counsel, I'm putting off sentencing, we'll take this up at a later date, and they do that. And then we have a hearing, and then we can bring up the IAC and the direct appeal because it's all part of the package.
As I understood your brief, your position is that by counsel standing mute beside Mr. Sharkey, Mr. Sharkey was totally deprived of counsel for purposes of that motion, and it was a temporary, chronic situation.
Yes, that's
Complete
correct.
deprivation of counsel.
I think, yes, that's where I ultimately ended up with my shotgun approach, yes.
Okay. Any other questions? Thank you, Ms. Davis.
Thank you.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. I guess to some extent I'm somewhat confused. I thought that this court's case in Kingsley was this exact situation. And in Kingsley, the court indicated that with respect to both the statutory right to counsel and the constitutional right, that there's some latitude in there. And I think that latitude is what this district court judge attempted to discharge his duty. He was trying to inquire. He was doing exactly what, if not the only thing, short of automatically giving a defendant substitute counsel every time they say the word conflict, which is unworkable. This district court judge was attempting to do that very thing. He was absolutely stonewalled by the defendant, not once, but twice. There were some questions about whether this case would change if the district court judge would have taken the opportunity to inquire. That's exactly what he did, twice. He took that opportunity. Short of an automatic appointment of substitute counsel, every time someone files, says, mentions a conflict, I don't know how else the judge is supposed to resolve this situation. And with respect to the comments, with respect to the option of a 1507 thereafter, it was my understanding under Rice and Rowland that these, and also I believe at least Rowland, this court's case, was that in order for him to be more or less stopped from asserting a claim of ineffective assistance later in a 1507, these claims not only had to be ruled on, but they had to be addressed. That's the point. They weren't addressed here. There's nothing stopping.
But if it was the defendant's fault that they weren't addressed, then he wouldn't be able to bring them again, would he?
I don't think this motion, as far as I know, the claims in this case, and any case like this, I can only speak for myself, and I guess and what I understand the law to be. There is no way that we would make a claim that he's had a prior 1507 or a prior claim of ineffective assistance, and there is no way any of the panels of the Court of Appeals that I've been before or this court would accept on this record that this man has had his claims of ineffective assistance of counsel litigated such that he could not bring them again. Plus, there would always be the exceptional circumstances. So whether you would find that he's never had the claim litigated or that under exceptional circumstances he could raise them again, I am totally confused on the concept that this man would not be able to assert these claims later in a 1507. But that's obviously not the issue here. I read in Kingsley that the district court is supposed to do this very thing that the district court did. I read in Kingsley that there is no automatic statutory right to counsel under this situation, and I read in Kingsley that this court indicates that there is a relaxation of the constitutional right to counsel as well until you can figure out what's going on.
The problem I'm having under the facts of this case are that I agree with Ms. Davis. This was on its face, Mr. Sharkey's answers were contradictory. And so at what point does a trial court stop and go, okay, it's obvious he's not understanding what's happening here, and at least ask, so does that mean you're withdrawing your motion? I mean, that seems to me to have been a logical next question after the second no.
And Your Honor, respectfully, that may have been a better response. But time and time again, I'm before some sort of court where they point out to me what the better response would have been, and respectfully, I think we need to address whether what was done here was error, and I think that shoots right into Justice Rosen's.
But the point of all of this is that Mr. Sharkey, at a minimum, needed to be told if you're going, given some advice by someone, didn't he, to pursue this? When it was obvious to the court that he was not understanding it, don't the cases require more of the district court?
Well, I think that's where Justice Rosen's comments come in. And this is not someone who has. This is the first time I've alleged a conflict and so forth and so on. I mean, who's to say that? I believe it was the district court judge. Who's to say that they're not recalling that? I mean, we're looking at a vacuum, and you want some further indication that this person has been advised of some nature. Who's to say that he wasn't within those earlier 4 attempts? At some point, the district court judge needs to proceed on to sentencing, and when he's tried twice, I don't think that these comments conflict each other at all. What they show is a conscious effort on the part of the defendant to not to not litigate this or pull forward with it. I think that what I've seen in the past, and I'm sorry to go outside of the record, but what I've seen in the past is these exact same motions filed, you show up, and they will withdraw them. The motions are withdrawn upon the inquiry. And I think that's what this district court judge was doing, is the best that he could do at that time to figure out in these circumstances, what are we doing with these pro se motions?
See, I guess the problem I'm having is it seems like on this record, we're having to read a lot into the record, one way or the other. It just doesn't appear that there was an adequate record for us to know what the situation was here. We're guessing. So what do we do with that?
Well, I think we, obviously, I understand I can't change that now. The record is what it is, and what happened, didn't. But I think that this court can be somewhat comfortable with the result here, in that, as the district court judge indicated, this is not the end of this case for Mr. Sharkey. He has the ability to raise each and every one of these claims plus more in a 1507. So it's not as though these issues are not, it's not as though he's been stopped from litigating these issues. And he may, in fact, be better off in that now he, not that he couldn't raise ineffective assistance of appellate counsel later, but would have that ability now and bringing it all at one time.
I'm looking at your brief, and it's got a little bit of the transcript, and the court responded after defendant said, after court inquired, are you going to stand on your written motion? The defendant said no, and then the court goes on to say that the record should reflect that defendant shaking his head in the negative, and after reviewing the motions, the defendant chose not to testify and has alleged various reasons in his motion that he felt like he was hoodwinked or whatever, but the court recognizes there were some serious downsides to the defendant testifying and being cross-examined, and he has a Fifth Amendment right to remain silent, not to incriminate himself, and he chose to exercise that right. The jury was told that with the court's instruction, and heard that in connection with the verdict. So the motion for new trial and motion for reappointment of counsel will be denied. And so I'm trying to understand why that wouldn't be a ruling on the merits of the ineffective assistance of counsel that was raised in those motions that the court identified was being presented.
And then for the same reason that I indicate Rice and Rowland, I always get the two confused. I think that one might be the extension of the other. I think that there is no way that you can say that this was this man's opportunity to present this. If anything, as I believe it was in Rowland, anybody that's going to look at this is going to indicate that that this person was not able to flesh out these claims. And I will always maintain, as well as I believe what the district court's unspoken word was, is these claims were conclusory. These claims were outright conclusory. If he wanted to litigate these now, the simple answer would have been, well, your allegations are conclusory and we're done. He always tells us that there's, oh, well, I've got all this wonderful people that are going to say stuff. That's basically what this is. There's no substantial question here to have a hearing on. I'm now convicted. I'm going to prison for at least 25 years. And something went wrong. It's his fault. There's people that would say things that would change stuff. It's just impossible. There's not grades of impossible. It's impossible to have a hearing on something like that. And I think that what occurs on our Justice Johnson read on page 5 of our brief, I think that's more or less the district court's way of concluding the pro se motions. I don't think that even the district court would indicate that this was an absolute ruling on the merits of these claims and he'll never be able to raise them again. I think this is just his way of moving forward. As he indicates at the beginning, first we'll take up your pro se motions, see where we go from there, and then maybe we'll get to counsel's motions. I think that's just his way of concluding in an orderly manner so that we don't have a claim later that the pro se motions were never ruled on.
And he does conclude that later by saying that there would be first and foremost the remedy of a direct appeal, which you'll be entitled to given the life sentence to the Kansas Supreme Court. But in fact, if he had raised that on direct, at most he could hope for Van Cleve, and it would have gone back for a hearing with new counsel.
Well, to have it addressed on direct appeal, yes, but that's still The other part of the statement is that he could raise, if he feels strongly about the ineffective claims, he could raise them in the 1507. I believe that's in there as well.
Yeah.
So I would ask this court to do nothing more than to apply its precedent as indicated in Kingsley and find that the district court judge did under the circumstances what he could do with respect to any harm to the defendant. There is none. I don't think that there's a chance that he was barred from raising anything that he could have raised before. And in fact, I think he can improve his situation, maybe as Justice Johnson has indicated. Why didn't I get a Van Cleve hearing on appeal? Unless the court has any questions, we'd respectfully request that the district court's decision be affirmed. Thank you.
I would waive rebuttal.
Any questions for counsel? Okay, thank you. Court will take this matter under advisement. The court is now in recess.